Good afternoon, everybody. My name is Danny Ford. I'm an attorney at Goodman Law. Here with me today is my colleague, Liz Lindblom. She is also an attorney here at our office. And you just briefly heard from Christy, who's our firm administrator. And we expect there to be quite a number of participants today. Christy's going to kind of assist in the background with admitting folks, monitoring the chat if there's any technical issues or questions that are posted or anything like that. We will try to kind of keep tabs on that as well and make sure that we can get to everyone's questions. Um, probably let's see, it's 12:02. So yeah, well, we can go ahead and get started. Welcome everyone to our Lunch at Learn. I appreciate everyone taking the time out of their day. I guess I should actually call it a Learn at Lunch since we are not serving lunch. So the topic today is a new case that just came down out of the Arizona Court of Appeals almost exactly a month ago, just over a month ago, that we felt was very important, very relevant to our daily life as attorneys in the HOA world, but more so for you all as managers or in some capacity for a management company, or even possibly, I believe we're going to have some board members on here today as well. So this case is very relevant and very important, and luckily, it's a very good case for us in the HOA world, working with or for HOAs, as opposed to some other cases that have come down in the last few years that have been not so helpful for us. So before I start the slideshow and actually get into the meat of why we're here today, if any of you guys have attended a lunch and learn or a learn at lunch with us in the past, Clint Goodman usually hosts these or does often, and he always likes to start off with some jokes. Sometimes they're weird laws, sometimes they're jokes about HOAs. Sometimes I think maybe he makes them up. I'm not exactly sure, but I kind of like that, and I'm going to start off with sharing some jokes with the class today, and I hope you guys think they're funny. I thought they were humorous when I was researching and putting them together. So they're like jokes and one-liners. So let's go through just a few to kind of get things going, and this will allow a couple extra minutes as folks do trickle in as well. I want to make sure that everyone gets the full extent of the information we're sharing today. So here we go. Without further ado, jokes. So my first joke: I asked my HOA if I could paint my house an exciting new color. They said, "Sure, it can be bold beige or aggressive tan." In Arizona, I thought that was funny.
You
My
really
my
just
second
combined dad jokes with HOA jokes there, didn't you?
Well, someone has to do it. For the record, I am not a dad except to animals. But hey, if the shoe fits. My second, here's an HOA life tip for everybody. If you can't find the rule, it's either in the CC&Rs or it's about to be. As lawyers, we think that's probably funny. Um, the board asked if they could if they could just make an exception this one time. My response was, "That's how you accidentally create an Exhibit A to future litigation. So don't do the one time exception." Um, Reserve studies are like gym memberships. Everyone agrees they're important. No one wants to pay for them. And finally, I hope some of these are hitting, maybe not. I don't hear any laughter, but that's okay. The governing documents say one thing, state law says another. The homeowner read something on Facebook. Welcome to the world of HOA law. So, okay, well, I hope maybe we got a giggle from a couple people. If not, appreciate you guys sticking with me through this. So, okay. So now, actually, without further ado, those were fantastic. I appreciate that. Thank you for helping my confidence in this. I appreciate that. Thank you. Okay, so I'm going to go ahead and I need to real quick switch myself to host. Actually, Christy, could you make me host, please? So I can share my screen. Oh, I have a couple comments from people thinking those were good. I appreciate that. Thanks, everybody. Okay, I am now the host. So let me go ahead and share my screen. Can everyone see my screen now? Um, which should be a PowerPoint
Yes.
presentation deck. Okay, fantastic. So I'm going to leave this one over there like that. We don't have a huge PowerPoint presentation today, but we have a lot more discussion around everything. So we're going to try to do this as more of a discussion format. And please, we like it to be collaborative. So if anyone has any questions, you can throw them in the chat. If anyone has any examples, this is not, this is not supposed to be a formal legal training per se. But if you guys do have any questions or if this kind of brings things to mind, please do, to bring that up to us. And then as we go through this, Liz may have some examples to chime in. And at the end, we are also going to do more of an open discussion Q&A section. And we even have a hypothetical for you guys that Liz is going to handle as well. So we can try to make this as relevant as possible and as applicable as possible to what we all handle on a day-to-day basis. So before we actually get into the case that we're here to talk about, who does anyone? Well, I guess I'm going to ask the first question. Who or has anyone here ever been involved in one of their associations being sued?
Yep.
Maybe the and maybe yep. And then maybe the follow-up question: does anyone have real briefly? Can anyone tell us what was the basis of the suit? We're gonna. I should have specified a association being sued by a homeowner. What are some of the things that we hear of, or the reasons why associations get sued by homeowners?
They didn't follow the rules and regulations of the association, didn't do fiduciary responsibility, didn't hold meetings. Yeah, all those fun stuff, didn't follow open meeting laws, and they lost. Go figure.
Oh, that's not the best result. Okay.
Oh
Well,
yeah,
but
they were sued on 16 different accounts and they lost every one of them. And we told them not to do it.
16.
We
Wow,
told them everything not to do. They just chose not to listen to their attorney nor to listen to the management company. We did fire,
yeah.
of course, but
Yeah, that's unfortunate to hear, Evelyn. Definitely doesn't sound like it was a good case. That's a lot of claims, and that's unfortunately a lot of losses. Side note, this is a shameless plug. If you ever have difficulties with your boards, especially new boards, young boards that are not understanding their fiduciary duties, especially, and some of the things that Evelyn was just talking about with what we call the business judgment rule, which helps to protect associations, please reach out to us or whoever legal counsel may be for the association. Always happy to conduct board training so that we can maybe avoid some of these things going forward.
Hey, Danny, this is Eric.
Yeah. Yes, Eric.
I just wanted to let you know that actually my association got sued twice when I was a board member, and your firm actually won both cases.
Oh, well, thank you. I appreciate that, Eric.
Great.
Very nice of you to share.
What was
we
the
try our
cause of
best.
action? What did they sue for?
Okay, so the first one, it was a renter that sued for defamation of character because on a Facebook post, it was posted that she was nuttier than squirrel turds.
Okay.
Clint will have some great stories about that one. And then there was a former board member that was served a cease and desist letter because he was riling up the neighborhood. And he was also a member of the National Guard, was told that if he did not cease, that he was going to have a letter sent to his commanding officer, which did get sent from your office. He was reprimanded, so he sued for that. It actually went up to the Arizona Supreme Court, and they chose not to hear it after he lost.
Very good. Well, good results to share. I appreciate that. Does anyone else have any examples real quick as far as associations being sued by homeowners and what was it for? All right. Well, we'll get right into it. So, the So the case we're here to talk about today is, and I apologize if I'm mispronouncing this case name. I call it Igtunheimr. It's a company that owns a property within the Val Vista Lakes Homeowners Association. And Igtunheimr, again, if I'm pronouncing that correctly, well, we'll just get into, why don't we just get right into what the case is about and what we're going to talk about today. So first of all, first and foremost, why does this case matter? I'm going to give you just a real brief overview and then we'll get into the actual case itself. This case has to do with what happens when an owner sues an association for alleged, usually lack of maintenance. So homeowners associations, condo associations, doesn't really matter which. We know, depending on the documents, they usually are in charge of maintaining something, and sometimes they're in charge of maintaining a lot of things. Common areas is probably first and foremost present in every community, whether that's one tract or maybe lots of them. So common areas, pools, amenities such as gyms and clubhouses or whatever it may be. Maybe the association has to maintain roads. There's a lot of things. If we're in a condo, we're talking about roofs, exterior building surfaces, a lot of things that the association may be responsible for maintaining. And sometimes the associations get sued if an owner believes that those things are not being done, that the association is failing, is breaching its contract, breaching the contract, the CC&Rs or other governing documents, or simply the association is failing to do something that the owner thinks the association is responsible for doing. So what happens a lot of times, and we didn't necessarily have an exact example from the group here today, but this is a very, very common case type. Owners suing associations for lack of maintenance, or what's usually lack of maintenance. I don't think anyone sues an association for maintaining too well. That would be kind of humorous, but usually it's because the association hasn't done something. So what this Igtunheimr case does here for us in Arizona is it provides, first of all, some clarification on maintenance claims and more importantly, who can bring those. And I'll explain that in just a second. It allows us to kind of have a different strategy when we're managing the level of risk and potential exposure to the HOA. And again, we'll talk about what we mean by that. And then it also kind of gives us a different perspective on how we're going to handle these things going forward. What can we do on a proactive basis to try to limit some of these claims going forward? And also, how are we going to handle things when we're being reactive, let's say after someone either threatens to file litigation against an association or perhaps has already done so. So with that being said, let's get into the actual case itself. Like I said, this is Igtunheimr versus Val Vista Lakes. I'm not going to ask if anyone was directly involved in this case or if anyone on here has any affiliation to Val Vista Lakes. We'll just keep that between ourselves. But what basically happened, or the background, Val Vista Lakes is a very, very large master plan community. It's approximately 2,200 homes. So this is a big one. And Igtunheimr, again, is a company that owns a property. Investment, rental, doesn't really matter. It's not a person's name. And so this property owner within the association filed suit against the HOA. And the owner claimed that the HOA didn't do a bunch of things. And so some of those things, as you can see here, is that apparently the HOA was neglecting caring for the pools and the pretty lakes that are in the community. This is not a picture of Val Vista Lakes. Clearly, that's not even in the state of Arizona because we don't have neighborhoods that look like that. But they were not apparently taking care of the pools and the lakes. There were some issues with maintenance or quality within the clubhouse. The owner was complaining that the parks were not being maintained. The green belts were not being maintained. There was issues with walls, fences, plumbing, electrical systems, paving of the roads. The list goes on and on. The point being is this owner was very angry about a lot of things and thought the association was violating its own CC&Rs. And so the homeowner sued the HOA, sued in Maricopa County Superior Court. What ultimately happened, just to kind of give you a brief precursor, is that the owner sued the apologize, guys. I'm trying to get my icons back. So the owner sued the HOA. The owner lost in Superior Court, and then the owner appealed to the Court of Appeals in Arizona. And the Court of Appeals affirmed. The Court of Appeals agreed that the Superior Court was proper in dismissing the lawsuit. So that's nice to see. We don't always get pro HOA case holdings, especially at the appellate or Supreme Court level. So this is a good one for us to use going forward. And so let's kind of get into what happened and why. So when this owner sued the HOA, the owner did what was called a direct claim. A direct claim meaning the owner sued in essentially, I'm going to say its personal capacity because it's a business that owns or a company that owns this property. The owner sued in its personal capacity, even though all of the owner's complaints were about things that the association was apparently deficient in or doing incorrectly or improperly or not at all as a whole. So when you think about why owners sue HOAs, we heard some examples about violating open meeting laws, let's say. Sure, that's a good one, and that does come up. But a lot of times, owners will sue HOAs because they're upset about something, like the pool is not maintained, the pool was closed for too long, the gym is not up to their standards, whatever it may be. And when you look at common areas, common elements, common amenities amongst planned community and condo associations, those are not there to just serve one owner. Those are there to serve the association as a whole. All of the owners within the community, whether it's Val Vista Lakes or something much, much smaller, all of the owners in the community are equally able to use and enjoy the common areas and the common amenities, right? So it's when you have one owner that is saying, you HOA violated the CC&Rs or other governing documents because you failed to maintain the pool, let's say. Let's just use one example as the pool. The owner made that claim as if only that one owner was personally being prejudiced or was somehow damaged because of the HOA's alleged lack of maintenance, right? And the reason I'm kind of drawn attention to this is what it ends up being is this a discussion, and this is what we're here to talk about today, this discussion of a direct claim versus a derivative claim. So taking a quick step back, as we know, homeowners associations, condos associations, anything that's subject to either act, behind the actual HOA is a nonprofit corporation. So because of that, Nonprofit Corporation Act in Arizona has a whole bunch of laws of what we can and cannot do. This is where we drive a lot of things about records requests and open meeting laws and member and director duties and all of these things, right? And so derivative lawsuits, direct lawsuits, a lot of this comes from corporation law. So let's kind of go into what is a derivative claim versus what is a direct claim, and why does it matter? So to kind of jump, to give you the end, I already told you that the Court of Appeals affirmed the holding and the association ultimately prevailed. And the reason that the court held this is because they determined the homeowner's claim was supposed to have been a derivative claim. A derivative claim means that it belongs to the community as a whole, but the owner sued in a direct fashion. The owner's claims he tried to make was just like that he or it was being damaged by this alleged lack of maintenance. But really, that claim belonged to potentially all owners within a 2,200 plus home master plan community. any owner, it doesn't matter where, it doesn't matter for how long, could have theoretically brought those same claims for the pools, the parks, the roadways, the pathways, whatever it may have been. Any of those owners could have brought those claims against the association, but this owner did it in his individual or in its individual capacity, not as a conduit or a representative of the greater class of people, being the entire membership within the HOA. So to go through in a little bit more detail here, a derivative claim, as I explained, is supposed to be a lawsuit brought on behalf of the entire association and not one that is for just personal damages. And so in our world here within the HOA, what that means is if the entire community is affected, that's supposed to be a derivative claim. Again, I know I'm repeating, but if the pool is not being maintained and you have all of the members with access to the pool, that pool serves everybody, or is supposed to at least. All the owners have a right to use the pool unless perhaps they've lost their privileges, which is a different conversation. But everyone has access to that pool, presumably, and everyone could have the same complaints about the pool maybe not being properly maintained. So again, if the entire community is affected by this alleged lack of maintenance, that's actually supposed to be a derivative claim. Generally speaking, absent some really strange circumstance, maintenance of common areas is almost always going to affect everyone for the reason that I just explained, because everyone has access. Everyone has, if it's a condo, everyone has common ownership. But everyone could benefit from or should be able to use and enjoy common areas. It doesn't just affect or doesn't only benefit one owner. That's a derivative claim. In contrast is what's called a direct claim. A direct claim is when the injury or the damage, whatever the person is complaining about, when that damage or injury is unique to only one homeowner, that is probably going to be a direct claim. And that's really what this Court of Appeals case in Igtunheimr really centered on, and that's what we're talking about today. So let's go a little further into why that matters or whatnot. Generally speaking, at least in Arizona, and this is probably pretty common across most states, but at least for Arizona, for the purposes of today, individual homeowners usually lack standing to bring a lawsuit on behalf of an entire HOA. And by standing, I mean, do they have the right to actually bring the case before a judge in our Arizona courts? Arizona has laws on this because, again, going back to what I said a moment ago, these are nonprofit corporations. This is a business we're running, even if it's for a very particular purpose and we're not actually doing it to make money. So nonprofit acts and related laws in Arizona to sue on behalf of an actual HOA, on behalf of all of the members, which I was saying is called a derivative claim. To do that, there's restrictions in place. In Arizona, for example, you have to represent at least 50 members, 50, or you have to represent 25% of the voting power, whichever is less. So if you have a small community versus a very large community, whichever is less, between 50 people that are basically signing on to this lawsuit, or 25% of the total number of people within the membership that could sign on to this lawsuit, the person suing would have to basically be in that capacity. They're putting, Igtunheimr could have put its name on the lawsuit, but it would have had to do it in a representative capacity for a bunch of people. Lots and lots of homeowners, especially in a community the size of Val Vista Lakes. And before they actually file a lawsuit, they have to make, this is according to law, they have to make a written demand on the association. Basically, like we send demand letters when you refer a file to us, and we send demand letters because people owe assessments or because people are in violation of some provision of the CC&Rs. they have to make a demand to the association that makes the association aware of what is alleged lack of maintenance items or complaints or concerns, whatever it may be. They have to make a demand that outlines what those are and basically demand that the association fix it. The association would then have an opportunity to cure those things if it deemed it needed to or was relevant. And then if that didn't happen, or if the person, owner, representative making the demand wasn't happy, they could then proceed to actually doing the lawsuit itself. None of those things happened here. So what the court saw in Igtunheimr was that this person or this company that owns this property was making a demand and claims against the association for, as you saw in the first slide, all sorts of alleged lack of maintenance things. Which was really something, again, that would concern the entire membership. But the Igtunheimr never actually had consent or representative capacity for anybody besides itself. So it wasn't actually representing a class of members or the full membership, and it never made a written demand on the association. So throughout, if you review all of the pleadings and through the Superior Court and even into the appellate court action, they tried to argue around this after the fact. Igtunheimr, through counsel, tried to kind of revamp its arguments. It was trying to relabel the claim as a representative claim, as a sort of derivative claim. But the Court of Appeals, the Superior Court, first of all, saw right through it and said, no, that you didn't plead this correctly. You're representing it here. You have one home. You made no written demand. You're not actually representing anybody else that we're aware of or that you've said that you are. And so you don't have standing. You can't bring, and you made no written demand. You can't bring this claim on behalf of everybody in a derivative fashion when you've pled everything as if this was a direct claim. So that's why the court ultimately dismissed it. When it went up to the appeals court went into a brief but comprehensive analysis of what we're talking about with this direct versus derivative claim, why it matters, and then ultimately affirmed the lower court's decision and said, yes, lower court got it right. The association wins. This individual homeowner brought the wrong kind of claim. This individual homeowner cannot bring a claim as it did. And as I said a moment ago, generally speaking, when the entire community is affected, not just one individual homeowner, it has to be a derivative action. You have to go through these obstacles or these prerequisites in terms of number, written demand, etc. And you have to do that before you can get into you can do this in a representative capacity and sue the association for all of these things that you claim it's not doing correctly or inadequately or whatever it may be. So that in that determination of whether it's a direct claim or a derivative claim, that's a legal question. That's something that the courts are going to determine. And that's something that the courts are going to they're going to overlook, even if you label it as one, but it acts as the other. The courts are going to see through that. They're not going to just relabel it for you. They're not going to redo your claim for you. No, they're going to kick it and say, as they did here, sorry, you lose. This is not a proper claim, because they're going to look at the actual real injury or the real damages that are being alleged, not just some cute buzzword that the owner's trying to use so that they can keep the claim alive.
To piggyback off that, one of the big reasons of practicality that the court discussed was that, in theory, had they allowed this one homeowner to proceed and possibly recover damages if they were to prevail, then what that does is open the door for the other 2,200 homeowners within Val Vista Lakes community to do the same thing, which is why those types of claims are required to be done as a group, because there would be no victory, no way of surviving if they were each allowed to individually make that claim.
Exactly. Spot on, Liz. Thank you. And so again, let's look at this from the business law perspective, corporate law perspective. this is a corporation that we work for, with, etc., a nonprofit corporation, but still a corporation. Think of a big corporate company that is a publicly traded company and has technically could have millions of shareholders if we're talking about something that's traded on the stock market. All of those shareholders are kind of owners in the company, right? And so if you had a company with 1 million shareholders and this company was allegedly doing something wrong, you could have 1 million, literally, of the exact same claim. That doesn't work very well for a lot of reasons. In the court system, it would just so completely bog down the court system that nothing would get accomplished. And the things that we're trying to do and everybody else's claims, civil, otherwise, would never even get a chance to see the light of day. So that's just a really burdensome, impractical approach. But what it also does is, or what also is the concern from the court's perspective and even the legislature's perspective, which is why these laws exist, is because you don't also want the ability for the court to possibly have inconsistent rulings. One judge, gives the owner more deference, or thinks it is sympathetic to the homeowner. That never happens, right? So one judge is sympathetic and rules in the owner's favor, and then the other judge across the hall with the same fact pattern, the same allegations, says no, the HOA wins. Now you have this inconsistent world of case law that we live in, and that's not going to work well either. So to Liz's point, it's primarily to prevent hundreds or thousands of duplicate lawsuits. When what they're trying to do is they're trying to ensure that the lawsuits that are filed, talking about specifically derivative lawsuits, that these lawsuits actually represent the community's interests. And they're trying to prevent the association from literally being drained. Can you imagine if you had an association that had 100 or 1,000 of the same lawsuit going on all at the same time? The amount of money that would be spent, whether it was through general counsel like my firm or through insurance defense counsel or whatever, it would bankrupt every association out there. And that's, of course, not going to help anybody, and not what we're trying to accomplish here. So as you can see on the screen, there, kind of what we just talked about, we're trying to ensure that the derivative requirements under state law are being met. We're trying to prevent this legal overload of all of these lawsuits that are on the exact same issue, which just is inefficient. And what this case also does, and what we need to further differentiate is direct claims do exist. If you have a situation where, I believe it was Eric that brought up at the beginning, an owner or a lawsuit, that one of the claims was about where a particular board member, or maybe it's an ex-board member, or a particular member is being individually harmed because maybe there's some sort of adversarial relationship, and a board is using privileged information or executive information to harass or go after one owner. That would be a direct claim if that owner sued, for example, because only that one owner is being targeted, or so they would say, right? And there's lots of other examples as well, but this is not to say, this ruling for Igtunheimr is not to say that direct claims don't exist or direct claims are not allowed. It just needs to be known, especially to homeowners attorneys, that you better be sure you're bringing the lawsuit or the claim in the correct fashion. Because if you're not, if you are trying to say that you were not personally injured, but the association, the membership as a whole is being injured, you have to bring that as a derivative claim. If you are personally being injured or attacked, or damages are ensued for something that only affects you, that's a direct claim. That's okay. But that's a very, very different lawsuit. And so going a little further into it here, let's talk about let's talk about what changes and what remains. Well, I just mentioned, for example, one thing, which is direct claims still exist, derivative claims still exist, obviously. We just have to be perhaps a little bit more cognizant or I should say, homeowners have to be a little more cognizant of what they're bringing, how they're phrasing it, and why. So what happened kind of before this case, or what used to happen, is that homeowners associations would frequently sue HOAs for these failure to maintain claims. And the courts, more often than not, let these cases proceed. Even though they weren't following the derivative claim rules for corporations, they would just kind of let these things go through, which again would cause duplicative lawsuits, or maybe it would even cause inconsistent results, as I explained. But what this case does now, what Igtunheimr does for us, is it really concretely establishes no, courts cannot do this. The nice thing in law, when you have a appellate court or a state Supreme Court opinion, is this now becomes what we call precedent. Precedent meaning this is now controlling law. It's case law, but it's still law in the state of Arizona. So if we have a homeowner's attorney that files suit and files suit as a direct claim, even though it's supposed to be derivative, what we now have is really recent good law that all the courts are now bound by, appellate courts down to superior courts. All the courts are now bound by this decision. So we can use Igtunheimr to say, no, this is not allowed. And so what's going to happen after this case, or what perhaps has already happened in some situations over the last 5 weeks since this case came down, is that a lot of these lawsuits, if they're not pled correctly, if an individual homeowner is making what appears to be a derivative claim for a failure to maintain situation, and they haven't done the written demand, they haven't done it in a representative capacity, these cases are now going to, or at least should be, dismissed very, very early on. So the courts are going to have to take this. They're going to have to use this because this is, again, standing case law now. The courts are going to have to really look at the real nature of the claim, not just the label. You can't call it a derivative if all the facts and circumstances show that you're acting as if it's a direct claim. The courts now have to have basically a more fine-tuned lens in looking at these lawsuits and see what is the real nature of the claim here, not just what the owner is labeling as. In associations, from our perspective, this is really a big shift in HOA litigation, at least with these failure to maintain claims, because now we have a much stronger defense for, as I mentioned a moment ago, what's called standing. We can push back if a owner files, like if this Igtunheimr case was filed, something similar to it by an owner tomorrow, the HOA would be able to fight back and say, no, this owner does not have standing to bring this claim. We cite to Igtunheimr, the court's going to have to dismiss that case. So before we get into really costly litigation, before we maybe have to tender the claim to insurance, to the insurance carrier for the association, which is, we all know, we're trying to limit claims, especially in today's day and age. This could potentially get rid of that claim, that lawsuit, really early on without expending a whole bunch of extra costs. As I mentioned, though, what this case does have some limitations. It does not eliminate all lawsuits against HOAs. That would be nice, but it doesn't, obviously. And it doesn't eliminate direct claims. As I said, an owner can still file an individual lawsuit when there's some sort of separate, when the HOA owed them a separate individual duty, or when the homeowner suffered some sort of unique injury or damages that are not shared by the community as a whole. And so there's still going to be claims and lawsuits made, of course. We can't really prevent those, even though we wish we could. But now this is a really good way to hopefully kick some of these improperly pled complaints about failure to maintain, and hopefully it kind of curbs some of these some of these things from happening in the future. Because again, even though this legal opinion or this decision that came down from the Court of Appeals was not super long, it was very pointed. It's very blatant. It's very black and white, which in law, as you know, if you've ever talked with any of us at, let's say, a different lunch and learn or a free legal or whatever, a lot of law is not black and white. We always, an attorney's favorite answer is it depends. Everything is gray. This one was pretty black and white, this decision. It really kind of sets the stage for not a lot of arguing around this. So the last thing I kind of wanted to touch on before I turn it over to Liz is how does this apply to you? And this is going to lead into our discussion and our hypothetical that we have for you today, but kind of some of the practical takeaways of how does this apply to your community and what kind of conversations are going to be had early on with the board if an association gets sued by an owner. What we've kind of learned from Igtunheimr is that first of all, failure to maintain is no longer just an easy individual lawsuit. Probably should have never been to begin with, but unfortunately, that's how courts were treating it. Those claims usually belong instead to the association as a whole, and therefore they need to be brought by a person or persons in a representative capacity of the association as a whole. And what this also means then is that early legal review, and this is where, we're always going to say 100% of the time, if the association gets sued, it doesn't matter if it's justice court, superior court, what it is, always speak with legal counsel right away. Probably need to put the insurance company on notice, but also speak with legal counsel. Whether it's us or somebody else, doesn't matter, speak to legal. But what we're going to look at now is we're going to be able to perhaps stop this litigation from ending up being really long and really costly. We may have a means of stopping it right off the bat with a quick motion to dismiss, citing Igtunheimr, citing the things that we're talking about today, where the case dies before it ever has a chance to really get going. And so that's something that really shifts the power in the HOAs, into the HOAs for a change. And this is going to allow us to also change our responses even before litigation happens. Maybe we get a demand letter. Well, how would this demand letter turn into litigation if we don't respond and do it, or we don't do everything the owner wants us to do? Can they even proceed with litigation? There's going to be, as I mentioned a second ago, there's going to be implications with insurance handling. Maybe this doesn't need to be a formal claim opened up with insurance that then has to get appointed insurance defense counsel. That is going to be a really big, expensive claim on the carrier's policy that could result in premiums going up, or maybe the carrier drops the association after the claim is completed. So there's a lot of considerations that are going to be good for us as attorneys, you guys as managers, discussions with the individual board of directors themselves as far as decision making on what we want to do going forward. One of the other things that kind of leads into this, and we want to just kind of touch on as well, is ensuring you have a consistent practice. When we're especially talking about maintenance responsibilities, documentation is really going to be key. I just mentioned how we may be able to get a case dismissed if it's pled improperly, but that doesn't mean that there aren't still going to be properly pled lawsuits against associations for failure to maintain claims. Some associations may not be doing what they're supposed to be doing in terms of maintaining common areas or amenities. And when litigation is necessary, or when litigation is going to take place because we're kind of stuck with it, and there may be some exposure on the association side, documentation is really, really going to be key. We need to be able to show all of the reasonable things that the association has done to maintain, working with its vendors, responding to demands or complaints. Maybe that's in a formal response letter to an owner. Maybe that's in meeting minute discussions. But hopefully, that documentation is really going to be important. Hopefully, though, with this case being down now, it's also going to maybe give us an opportunity to hopefully not adversarially, educate homeowners on which claims are proper, and in the proper channels of preferably going through a management company so that we can maybe address these things. And if there is no liability or responsibility in the association, we can maybe feel a little bit more comfortable in saying that, because we know there's now some additional limitations on what litigation may ensue afterwards. So all that being said, the takeaway here, this really did change the landscape, or the risk landscape, with HOAs, at least for failure to maintain claims, because they now have to be brought in a derivative fashion. They have to be brought in a representative capacity by the entire association, which means there's these extra restrictions and requirements that they have to follow, versus just throwing out an individual claim because one owner is just upset with what's going on. So that kind of concludes our PowerPoint. So what I'd like to do now is turn it over to Liz, and have a hypothetical for you, and then we're going to also do some Q&A. So Liz, take it away.
Okay, so everybody, I'm going to present a fact pattern. And then all I want you to do is to determine would this be a direct claim or a derivative claim? And you're going to type your answer into the chat, just the word direct or derivative. And then I'm going to call on some people and see how we are determining whether it's either one. Okay, so this is a association that is a gated community. Therefore, the association is responsible for maintaining the roads. This association has not done a great job at maintaining the roads, and potholes have started to form. So owner is driving his vehicle through the community, and his car is damaged by a pothole. Would this be a direct claim or a derivative claim? Okay.
We're seeing a lot of direct so far.
Yes, they're seeing. All right, I'll just call out, let's see, Wade Barfield. Could you turn on your mic and tell us why do you think it's direct?
Because a single property owner's vehicle was damaged and not multiple property owners. Everyone else had the sense to drive around it. So I would say that only because the damage was to a single individual and not a group of people.
Okay. If anyone has a different reasoning than Wade, please feel free to turn on your microphone and say what your reasoning of why it's direct. Okay, now same fact pattern, but owner who damaged his car had his car insurance cover that, but he still sued the HOA. Would that be direct or derivative?
Or would it not change anything?
Still, to me, I would say it doesn't change anything because you simply have somebody acting on his behalf.
Okay. Does that addition of the insurance paying for the damage, does that change anyone's decision that originally thought it was direct? Does anyone think that now makes it derivative? We'll take silence to assume no.
Melissa says no, it's still direct. Okay. So
still only his car damaged, yeah.
There's a reason I actually chose this fact pattern, because it actually could go either way. And the reason why it could go either way is depending on how the lawsuit is filed. So if in this situation, for the direct claim, everyone, you are completely on point. That is absolutely, he's saying my car was damaged by your failure to maintain. Cool. I agree with you there. However, if the damage to his vehicle is taken care of, then what he's just left with is failure to maintain. So at that point, it would end up in that derivative category, only because we're taking the individual damage out of it. And all that's left is the general harm.
So kind of to add to that, everyone, so we were talking about how in Igtunheimr, the case that we've been discussing here today, he or it was making all of these claims about general lack of maintenance for the pool, the common areas, whatever. This owner in Liz's hypothetical, if the owner sued the HOA and said, you owe me $3,000 because my suspension was damaged on my car and it cracked a wheel and it blew out my tire. That's a direct claim, and all of you guys hit the nail on the head there. That he's just saying my car was damaged because you failed to maintain the roads. You owe me damages. You owe me money. I was injured or my car was injured, right? But that owner, maybe this owner has been fuming for a while about things, and maybe that was the last straw. And the owner didn't even care that his car was damaged because he had insurance pay for it, or maybe he just paid for it out of his pocket, or maybe he just parked the car and just never bothered to fix it. Doesn't matter. But if that owner felt so strongly that that was just such a violation to him personally, I don't know why I was saying him, I guess it could be a her, but if that owner was just felt so aggrieved that, you know what, I've had it, this association fails to maintain the roads, I can't handle this anymore, and that owner brings a lawsuit in a representative capacity for all of the members, that's probably not going to be a lawsuit where he's seeking some sort of monetary amount. He would just be saying, you HOA have failed. You have breached your duties. You have breached your covenants. You have failed to maintain when you were obligated to do so. And we want to hold you responsible. That owner may put their name on the pleading, but so long as he or she followed those prerequisites where you have to do it in a representative capacity of 50 people or 25%, whichever is less, and made a prior written demand on the association, that same fact pattern could end up being a derivative claim. Because at the end of the day, let's face it, failure to maintain roads really does affect the entire membership. And so that could be something that one owner takes on, but does it again in a representative capacity to where now he or she is speaking for the entire community and is trying to hold the HOA responsible for something that they allegedly have not done. So does that kind of make sense to everybody as far as the distinction, or any questions specific to that hypothetical fact pattern?
All right, Danny, if you want to stop sharing your screen, we'll open this up for 4 to 5 minutes of Q&A. If you want to raise your hand, then we can answer any questions that you may have. No questions? Are we that good?
No, we do have a question from somebody in our office.
It's me, Danny. So,
yes, Maura.
in terms of the applicability of this case, Danny, what would you say to an attorney who says, well, that's all fine and dandy, but that's not a published case, so we're just going to consider it irrelevant?
Well, so that is an interesting point. And so what Maura is asking is, there's I mentioned how this is case precedent, meaning it's essentially now law. There's a difference between cases that are publicly published, that all of us can look at and all of us can rely on, and what's called an unpublished decision. An unpublished decision is usually something that we call persuasive and not actually binding law. And my particular response to you, Maura, would be, I don't really care. This is still congruent with the corporate the corporate acts and laws. It's still, I'm going to still treat it as good law and something that I would feel comfortable relying on. And I think it would be a very difficult hurdle to have an owner's attorney say, no, the Court of Appeals got it wrong, whether it was published or unpublished. The Court of Appeals got it wrong, and somehow be able to argue around how derivative lawsuits are inapplicable or illegal, or the law around corporation suits against corporations somehow doesn't apply.
Well, Danny, this is HOA world, so that's already happened.
This is true. This is true. We do live in a very, very strange world.
All right. Well, in the interest of respecting everyone's time, I know we said we'd be done by 1. So just our last little food for thought. If you have a situation where a lawsuit is filed against one of your associations, it doesn't hurt to run it by one of us attorneys to see if it could possibly just be dismissed easily with a quick motion and not have to file a claim with insurance and have them defend a case. And if you liked our presentation, you can give us a 5-star rating on Google.
Nice plug, Liz. I just, from an administrative perspective, I know a lot of you are looking for your CMCA credit for this presentation. We are still pending our approval for that, but I trust it'll come through in the next few weeks. And as soon as I have that approval from CAMICB, then I will send certificates out to everyone that is on the Zoom or has been on the Zoom this past hour. If you are sitting with someone and signed in under someone else's name, send an email to marketing@goodlaw.legal, and I'll make sure that those additional bodies get their certificates as well. Also, in the next few weeks, we will have the recording of this presentation up on our YouTube channel. So we'll send an email blast out about that as well. Rebecca, I saw your hand up there. Did you have something? Or was that an old hand?
I was just going to do a thumbs up and I hit the wrong button. Sorry. I was like, oh,
well, thanks for joining us.
So thumbs up to you guys.
Thank you.
Well, thank you. We appreciate everyone coming. We appreciate the participation. We hope that this was informative. We hope that while we never hope that associations get sued, obviously, we know that is the reality. That is the world that we live in. And so we hope this was kind of informative and maybe will spur some conversations with legal counsel or with your boards when these types of demands are made or obviously litigation is filed. I did share my screen for a second longer so that you can see our contact, even though you probably guys all know how to get a hold of us anyways. If anyone has any questions or anything afterwards, please do not hesitate to reach out. But we really do appreciate everyone spending their hour lunchtime with us. And we hope everyone has a good rest of your day.
Yes, thank you.
Thank you.
Okay. You're very welcome. Have a good day, everybody.